MP Charlie Angus.
Thank you, Chair. It's an honor to be at your committee. And it's an honor to have the two ministers who have enormous respect for the hard work that you do. And I don't want to sound if I'm going to be gruff this morning, but since I only have 7 minutes, we have so many things to talk about, I'll try and keep things moving. I want to start off, Minister Philpott, with the, I think, extraordinary news about Grassy Narrows and the commitment there. I have to say, though, talking to the community, 50 years of broken promises, people want to know that this is going to happen. So Grassy Narrows says they can get the shovels in the ground to get this treatment centre in the spring. What do you see in terms of the timelines of responding to their needs and getting this really important facility built?
Thank you for the question, and I obviously want to acknowledge all members for their advocacy on these issues, but it's no secret that you have been an exceptional advocate on behalf of the rights of Indigenous peoples for a very long time, so I want to thank you for that. In terms of Grassy Narrows, you're right. It's, again, a story of 50 years of impacts to a community through no fault of their own, tremendous impacts of the environmental contamination that took place in the 1960s and to some extent has continued since then. We had a very good meeting yesterday with both the chiefs and communities of both Grassy Narrows and Wabsamung. They had a number of requests to us. The one that I was able to answer to them immediately that day was that we will make sure that they get the treatment centre that they want and need and have been asking for a very long time. The timeline on that, I know that they obviously wanted it years ago, so we are going to work very ambitiously. I have assigned one of my assistant deputy ministers to work on this directly with the community, and we will move things along at the most rapid possible speed.
Thank you very much. Minister Bennett, the issue of St. Anne's Residential School remains one of the unresolved horror stories of Canada. And yet we have lawyers for your department in provincial court fighting survivors on cases, and the factum of the federal government says that the right to procedural fairness is not applicable to residential school survivors. Why don't you believe that the survivors of St. Anne's have a right to procedural fairness?
Firstly, Charlie, I also want to thank you for all of the amazing advocacy that you do. And yesterday, when we had our interchange in the House, I misunderstood which of the cases that you were talking about. This case today, I think that you know that we are committed to ensuring justice for all of the victims of this dark chapter in our history, all childhood litigation, all residential school, and particularly these cases that still remain outstanding. What we have to be clear about is the government is not challenging any of the individual claimants in this matter, nor the outcomes of their cases. The overarching goal is to ensure that victims receive the compensation that they are rightly owed for their pain and suffering, and that there needs to be some integrity to the system. What's been happening up till now is the adjudicator has been making inconsistent and at times contradictory decisions when applying the legal concept of procedural fairness. So we have asked the court for the guidance for the correct interpretation of procedural fairness. So we actually want their guidance in how we go forward to make sure that this system is fair and everybody gets what they need.
I think the problem is that the lawyers for your department have taken the position, quote, there is simply no place in the IAP for the administrative law concept of procedural fairness. Procedural fairness is a fundamental principle of law, and yet your officials are saying that this does not apply in the case of St. Anne's. They further state, just your lawyers state, that the chief adjudicator is relying on a, quote, bald proposition that the obligation to ensure a fair process for claimants falls on all parties. The one party here is the Government of Canada that chose to suppress 12,000 pages of police evidence, witness testimony that identified 200 perpetrators of sexual crimes against St. Anne's. The other party are the survivors who have no resources. So why is it that you would have lawyers in court saying that their right to procedural fairness does not exist?
I think that, firstly, I think you know that Justice Peral has said that we have released all the documents that were required. So I think that is settled. I think what we are in court now doing is determining what is the application, or what is the actual definition that could be implemented on procedural fairness in cases, because of the adjudicator using it differently in different cases, and we need guidance so we can achieve fairness for everybody.
The problem is that lawyers for your department now are in the hearings saying that the evidence that you were forced to turn over is inadmissible unless they can provide a survivor witness, which is to re-victimize the survivors who've gone through this, and then to claim that they have no right to procedural fairness. Minister, this goes back to the decision that was made high up to suppress evidence. And for the life of me, I cannot figure out why this was allowed to happen. When you had the names of the perpetrators, when your officials knew who they were, and you had cases thrown out because your lawyers said those survivors had no credibility because they weren't believable. When you had the names of the perpetrators, why? Why would Canada do that?
Very short answer.
I believe that Justice Peral has made it clear that all the documents that were required, or all that they expected, have been submitted. So, and I think
there's complicity, and the question is the complicity of Canada. Why?
So, the law is the law, and we are, in so many cases, Charlie, we are going way beyond what the law asks us to do. In so many cases, whether it's Anderson or, because Labrador and Newfoundland weren't in Canada yet, we are settling that case. I believe that our approach as a government is to do the right thing, not to just do what the courts tell us to do. In fact, we are spending as much of our efforts getting out of court to the negotiating table. So things like the 60 Scoop, get language and culture, get apology, get commemoration, get healing, that those are things that courts can't award, and that's why we're trying to get out of court on as much as we can.
Thank you. Questioning now moves to MP Ananda Singh.